Hello and welcome to the English show at Beltran Brito. My name is Stephanie Matza. Here accompanying me is Andrea, our all-star, who is not AI.
I'm not. I am real. Here I am
Let me see.
in the flesh.
She is real, it turns out. Welcome to the English show. For those who may not know us, we answer all of your immigration questions live. So ask away, and we'll go ahead and answer. I'm sorry, it's a long day. The thing about the English show is at 4. So by this point, we can no longer speak.
And I had this dilemma earlier. For some reason, I'm so used to talking to people in Spanish.
Oh my god!
That then I speak English and I forget words.
Yeah, I do it all the time.
Yeah,
I have to self-translate. And mind you, no, I was gonna say English is my first language, but it's not.
It's not.
It's just my easier language
forever.
Right. And it's still me cuesta, you see?
Yeah.
Anyway, we're gonna answer all of your immigration questions. You can ask us on Instagram, LinkedIn, on YouTube, on all the sites. And I think it's a really good, useful resource because everything's free, all this information, and we're providing it to you. So definitely share it with your friends. Let's talk a little bit of news. What news would you like to discuss with the people?
Well, Visa Bulletin is out in case.
Oh, yes. Let's talk Visa Bulletin. I love that idea. I'm so glad that we didn't pre-prepare for this because you know what? That just came.
It's natural.
All righty. So let's talk. First of all, Andrea, have they already announced which tables they're using?
Did. A second.
Okay. So last month they were using dates for filing for family and final action for employment based. I'm probably inclined to say they're probably using the same thing for June. But
family-based, dates for filing, employment-based, final action.
Okay, same. Beautiful. So I'm going to pull up a side-by-side on dates for filing on May and June for family-based. It looks like we had F2A is still current, which is fantastic. Talk to the people about F2A.
First of all, take advantage of it. That doesn't happen often.
Who is F2A?
So F2A is, I'll tell you right now because now I can't. Okay, spouses and children of lawful permanent residents. So that is, if you're able to do that right now, either in May or in June, that it's current, take advantage of it. We don't know how long it's going to last, and it usually isn't current. Like I said, take advantage of it. Spouses, children, lawful permanent residents.
Of green card holders.
Yes.
Alrighty, we've got small movement in F2B, which is the adult children of permanent residents. Fine, we moved from January to March of 2018. Small movements are movements, right? Let's talk about EB, and we're at final action for EB. So I'm going to go again on side by side, EB final action. Looks like EB1 and EB2 remain current. Phenomenal.
Yes.
Phenomenal. EB3 stayed at June 2024. Not great. February 2022 is still other worker. Okay, so there was literally no change whatsoever.
So after second preference, everything else stayed the same. So
you know who it was? There was advancements on China and India.
Which is important.
Which is
usually
very important.
those don't move that quickly.
Look, India had a hell of a jump. India jumped to December of 2022 they went backwards. They were at April 2023 and December 2022 now. Wow, that's significant. So India jumped backwards. If you are an Indian national, you need to consider either making the push to file in May while you're still current, while you're still able to with your priority date, or you need to already consider non-immigrant visa options because there was retrogression in for India. And it looks like for EB1 and EB2, both retrogressed. Wow, that's significant.
And that's what's important, guys. It does go backwards as well. So don't always think that when there's movement in the visa bulletin, it means that it's going to go forward. There is also times where it goes backwards. That's why I always say, if it's current, if your priority date is there, like if you're able to adjust status at that point, take advantage of it that month if possible.
Absolutely. All right. As far as other news, we don't have any updates on immigration pauses. Unfortunately, it's sort of the same deal. We have no information as far as when they're going to lift the immigration pauses. We mentioned last week this really cool website called USCIS Pause Tracker. Again, not sponsored, has nothing to do with us, but it is really cool. You want to tell them what it is just in case they weren't here last week?
It tracked to see if the pause is still active, like if it's still in pie. You see what I mean? It's going to be a thing today.
Mostly it's they're tracking the lawsuits. So there are currently 45 active lawsuits on this subject, and they're literally providing information as far as where each lawsuit is going, which in our opinion is going to lead to possible movement. And any sort of budge on the pause, I think, is going to be influenced by a lawsuit. So
it has to be.
Mm-hmm.
Hopefully we hear that there is some movement. We get constant questions about this.
Every single day.
Trust me. And also the issue is people then hear in the news that the pause has been lifted or that people are getting decisions. That's not the case, okay? Everything is paused. We promise you, whether it's on the Tuesday show or the Thursday show, or we'll post it on social media, the second we see any movement, it's not like we're hoarding it. Just we want you to just listen to actual sources, okay? Because you will have other sources that are reliable that will just say, oh yeah, we're seeing some movement. Things are moving along. No, not yet.
To be clear, you can still file I-130s, I-140s, I-129. So you could still apply for the benefit. The individuals who are paused are from having immigrant visas issued at U.S. consulates, okay? The majority of the pauses. But there's workarounds around that. You can enter the United States on a visa, on a non-immigrant visa, and then we could just do the whole process in the U.S. That is not paused. Yeah. So the pause has workarounds, and it really is affecting 75 countries, but believe it or not, in a minuscule way, because it's only immigrant visa processing, you could still basically apply for the benefit and already be sort of pre-approved, let's say. So it's not horrendous, but there are ways around it. Definitely speak to an attorney to make sure. Last things as far as information, as far as news, remember H-1B, you need to file by June 30th if you were selected in the lottery. Remember that you also have to request an LCA from the Department of Labor. That takes 10 days. So, mira, clock is ticking. You need to start moving on that LCA so you have it ready in order to file by June 30th.
Agree.
Let's go to the questions.
Yay!
Movement, some joy. Mira lo que te dice la gente. My abogada preciosa y favorita Andrea. Wow. Jorge Gaitán, please. Oh. Ale Tremola says we're his favorites. Please.
Come on. It's the girl show. There is nothing better than the girl show. Come on.
Alrighty. I'm going to start starring them and I'll let you in so you could go ahead and start answering, okay? If it's in Spanish, go ahead and translate to English.
All right. So we have, oh, by the way, guys, not wearing my glasses. So if you see me squinting, please, I apologize. So dears, if my husband applies for a passport of their home country by marriage, which is not part, like the pause doesn't apply to them, can he apply as a dual national? We already had the interview. They gave us a 221G. He's Colombian.
Dual nationals are clear.
Yeah.
Yep.
So yes.
Did you say you were a dual national on the DS-260?
Was he already a dual national then?
Mm-hmm.
That's important.
Si mi esposo aplicó para un pasaporte de un país por matrimonio. Aplica. Si mi esposo aplica por un pasaporte. So he's not currently.
So if he does do that, then he'll be a dual national, and that takes him out of those countries that are part of the ban, let's say, that are paused. So yes, that works.
So she's saying, is it worth it?
Yes. Yes.
Give her more.
Okay. Yes.
How long would it take?
So it depends on how long the passport takes for them to give it, depending on the country. But I would say yes, because we don't know how long this pause is going to be in effect. So we want to make sure, you want to make sure that your husband is able to apply by using that benefit that many people don't have. So take advantage of it 100%.
Yeah. The only thing I would add is to that point of how long would it take to acquire the other passport? Right. If the other passport would take 1 to 2 months, it's absolutely worth it, right? Because it's okay. Once you have the other passport, you're going to go into Ask NBC. You're going to notify Ask NBC via that platform. And then once you notify them, they could go ahead and basically retract the 221G administrative processing and issue the immigrant visa for him. If they're going to take a year plus, 2 years plus.
Even then, I would say, why not apply for it? Worst case scenario, maybe the pause is lifted.
Yeah.
But...
Yeah. Maybe that by that point, it's a different administration, so we no longer have this pause. But yeah, ultimately, it's a good idea to potentially have that as a backup. Alrighty, I'm gonna go with Jonathan Vasquez. I'm in an EB3 other workers process. My priority date is February 2022. I'm from Colombia. We are waiting on NBC and my consular processing. My oldest daughter is turning 21 years old on September 4th. What happens if for that date I don't have immigrant visa? So remember, you have to do a CESPA calculation. Typically, once you are documentarily qualified with NBC, you're pretty much in the clear. Okay. CESPA calculation has changed and it is more restrictive, but they will not count against you the fact that Colombia is currently paused and the fact that you're currently waiting. What they will count against you is your priority date for EB3, basically. So they're going to retract it from CESPA. Ultimately, the calculation is done by the officer. There's literally a worksheet that they use and they do the calculation. She should be fine, but I don't want to tell you with 100% certainty because between now and then we really can't tell.
All right, so we have Tim here. It's one of two questions. Hi, my TPS F1 change of status was denied last week. I filed an EB3 I-485 while F1 was pending and before the 180 days out of TPS status from November 7th. After F1 denial, when does unlawful presence start? I mean, technically, if you filed before the 100, I'm sorry, my apologies. If you filed, hold on, F pending and before 100 days out of TPS status, the 180 days did cover you, okay? Like in the sense that if you filed before those 180 days, your adjustment of status, you should be fine. So in that sense, the unlawful presence started when the denial, correct, November 7th. From that moment on, and because you filed the I-485 before those 180 days, you're good. The I-485 should be fine. Wait, there's another question. Does a pending I-485 still give me legal presence after the F1 denial? Yes. I always had a legal status before TPS, no asylum if denied, and I still pursue consular processing later. Yes, yes, you can. Yes to everything you just said. Thanks. You're welcome.
Yeah, as far as 245K, you're covered.
You
the
did it right.
The denial won't affect you.
And because he didn't have asylum before, he always had lawful presence.
Exactly. All right, let me go ahead and go with a case which is, I don't even know how to answer this. Laura Gill. Oops, where'd she go? Oh, you unstarred her. I saw you do it.
I was unstarring Tim.
I saw you do it.
I was meaning to unstart him.
Laura Gill. I have talked to 2 attorneys already and they told me each something different. How do I know who is right? Laura, unfortunately, I know the feeling because we're frequently told that, right? And I want to say we're frequently told that in a good perspective. So Gil said this last week, actually, which is, and this happens to me all the time. Someone comes to me and says, I've spoken to 3 attorneys and they said I do qualify, but you're the only one saying I don't. What's the deal? I can only speak for our firm, and our firm, I take great pride in the fact that we get to be a little selective with our cases. And so we get to be very honest with our clients. We're relatively, I would say medium-sized firms so that we're not desperate for these cases. We want to basically take your case if we know there's actually a chance to win. I'm not in the business of taking a case that I know there's 0 chance to win. I'm really just not in that business, right? And we're very blessed in that way that we get to say that. So oftentimes I will get individuals who come to me and say, everyone said I qualify. What are you talking about that you're saying that I still need more work? Yes, I will leave many consultations saying, hey, we still need a little more work in order to make this really polished and foolproof, right? Mind you, polished and foolproof under this administration has changed. What that means, right? Because there is a certain level of administration policy that doesn't really reflect even the best quality candidate, but we can get it as close there as possible. So as far as the question is, they each told me something different. That's difficult because I don't know what you're referring to. Are they telling you that, one says you do qualify, one says you don't qualify? That could be a matter of just like how strong they find the petitions themselves. You really want to take a good assertion. Go with your gut, I would say. But if they're each telling you something different as far as like actual policy and law, that one's a little more concerning, right? Like does TPS give you status or presence? That's something that like every immigration attorney really needs to know. So not tooting our own horn, but I would invite you to have a consultation with us because we do really feel that we have a good grasp on everything. So maybe have a chance to talk to us and have a third person and then see If 2 out of 3 agree, then maybe that's probably the route to go, right?
And I kind of want to add to that because it happens to me all the time. We like to be pretty honest with the clients because a lot of us weren't born here, so we know what it's like to invest in this kind of process. So the idea is to be as honest as possible. Like, you know, and I say it to my clients all the time, I'd rather tell you, hey, look, try to get me XYZ, and then we really reevaluate, you know, how the strength of your case and see if you have a viable case, rather than just tell you, oh, yeah, don't worry about it. We'll submit what we have, knowing well that that's not going to be enough. Okay. And that's not saying that there is a guarantee, because there is no guarantee with USCIS. Any attorney that gives you a guarantee is lying to you, honestly. And I say this often. So if it were me, I'd rather an attorney tell me, hey, look, try to get me this or that, rather than tell me, yeah, we're good to go, knowing that, you know, the probability of approval won't be high.
Yep.
Let's see. I saw someone right now. Where are you? Here you are. Mi columna vete, O1A visa for Venezuelans, waiting for adjudication and finish some kind of further review. Some weeks have elapsed premium. Any comment on this? So I'm guessing you paid for premium processing. Remember that because of the pause for Venezuelan nationals, even if you filed with premium processing, they are not taking the premium processing into account. So 15 business days for an O1A, which is supposed to be how long it takes to get a response, that's not being honored. Okay, so unfortunately, you just have to wait for now until we see some movement that they're starting to process all these cases for O1A or whatever it may be for Venezuelan nationals. And then based on what we're hearing, once they give these responses, these decisions, that's when we'll be able to request a refund on the premium processing if they didn't honor the times, okay? But they're not doing that before. They're going to do that once they give you the final decision.
Nice.
Yeah.
All right, let's go with Alejandro Osorio. I'm on an F1 visa and I have a pending I-140. I filed my I-45, I-131, and I-765, and I already have my I-797 receipts. Can I stop attending the school tied to my F1? You can, because now you have an I-45 receipt. Just note, if for whatever reason that I-140 were to be denied, then you can't just go back to your F1, okay? The second you stop studying and you only rely on your I-45 and you start using that work authorization, the I-765, God forbid that I-140 were to be denied, you can't suddenly go back to student. Absolutely not. You would have to, at that point, depart the United States once your I-45 is denied, okay? Now, here's the catch. And this is where some people say, well, it's worth continuing to study. If you do not use the work permit and continue studying on F1 and the I-140 is denied, you can file again because you have maintained your student status. Okay, you have maintained a non-immigrant status. But you can't maintain a non-immigrant status of F1 if you utilize the work permit that's tied to the I-45. So that's why you'll hear some people continue studying until they're confident their I-140 has been approved. But you can absolutely stop studying if you wish.
All right. Here's a question that kind of goes into what we just spoke about. It is from Manuela Villa, I'm guessing. How do I know if I really need an attorney for my case? I have heard stories of people who spent years, money, and a piece of their soul on something that ended up going wrong anyway. So this is the thing. Like I said previously, there are no guarantees, okay? But we do this for a living. So we sort of have an idea as to what USCIS likes to see, what needs to be submitted, how it needs to be submitted. So we're able to guide the clients in a way and pretty much do everything for you without you having to worry about that, in a way that we know that it's going to be accepted by USCIS and that you're investing your money in the right thing. Now, that doesn't mean that everything is going to go right, because that's not the case. Maybe a case will end up getting denied. But by working with an attorney, they'll guide you in a way, at least with us, I speak for the firm, will guide you in a way that we're giving you the highest probability of approval with what you have and the process that you're submitting. Okay, so if it were me and I'm doing an immigration process, I want to make sure that somebody that specializes in this is handling this for me.
I'm getting you the list of 19 countries just so I could verify. Miss Ba, I'm not going to continue to try that. I had applied for an H-1B transfer to premium processing. Receipt was received on February 27, 2026, but still the case is not adjudicated. We tried congressional inquiry, but no response as of yet. So just to clarify, if you are one of the 19 countries, and I pulled them up just to verify, so Afghanistan, Burundi, Chad, Cuba, Congo, Guinea, ay Dios mío, Eritrea, Haiti, Iran, Libya, Myanmar, Laos, Sierra Leone, Somalia, Sudan, Togo, Turkmenistan, Venezuela, Yemen. If you are any of those countries, they will not respect premium processing. However, I put your caveat there. The second you file for a change of petitioner on an H-1B, so an H-1B transfer, you can begin working with the new employer, even if the case has not yet been approved. That is only in the case of H-1B, okay, that special caveat. So you can already start working with the new H-1B employer. If premium was not respected and you're not from one of those 19 countries, then yes, congressional inquiry. And then later, by the way, you will be able to get and apply for a refund from premium processing. But if you are from one of the 19 countries, they will not give you a response within the premium. They're not respecting premium. You can continue to try congressional inquiry, but know that you can already start working with the new employer. Okay. You have to force me to speak slower because everyone says I speak too quick on this channel.
I got you. All right. So we have a question from Study It Street. I'm going with that.
Study it first.
Glasses, guys. Sorry. Why would a change of status from TPS to F1 be denied, and what to do in that case? So whenever we've seen that happen, it's because they're applying, for example, if you're part of one of those countries that have the ban, let's say, or some sort of restriction, we're seeing that they're applying the presidential proclamation, and they're saying that maybe you didn't show enough proof that you are beneficial to the U.S. So like that, you're pretty much saying that you're not a risk. You pose more of a benefit than a risk to the United States, even if you come from this country, okay? So we have seen an issue where we've gotten a request for evidence where they're indicating and they're citing the presidential proclamation, and they're asking for evidence to show good moral character, pretty much, okay? Which is something that shouldn't be the case because they shouldn't be citing the presidential proclamation. But that could be a reason why that TPS to F1 is denied. And unfortunately, if there's nothing else, no other status that's covering you, in that change of status that you did from TPS to F1, you might have to depart the United States.
We've had a lot of appeals. We have a lot of pending appeals on it.
We've argued this
consistently, because there was also this whole thing of like, there were USCIS officers that were not understanding that TPS, temporary protected status, is a non-immigrant status. So we have fought with them back and forth. Remember, Doge, Elon Musk entered USCIS. They fired a whole bunch of USCIS individuals. Immigration is a very complicated subject. So you have a bunch of new green officers that don't know what in the world they're talking about. We've had to appeal many of their decisions because they're just adjudicating these cases incorrectly. And I don't want to say by fault of theirs, but they just don't know. And Doge went and fired all the ones who were actually educated and have been doing this for 20 plus years. So we do have a lot of appeals in the works. But remember, to Andrea's point, that you appeal doesn't mean that you now can remain lawfully in the United States. So it's a very difficult thing that you have to follow. Hopefully that's not going to be the case for you. We saw a lot of denials before during that time, but it feels like we're no longer getting them. So I feel like maybe there was some sort of training internally.
Yeah.
Let's see. John Castrellon, could C9 be approved while I-140 and I-45 pending? How long does it take? Yes. So C9 is just the category for I-45 pending. It does not matter, and it's irrelevant whether or not the I-140 has been approved or not. They can issue it, and work permits are currently taking, if you're not from one of the 19 countries, currently taking about 2 to 3 months, or 2 months after biometrics, I would say.
Agree. All right. Let's see. Right here. If you had to choose, this is Jasper. If you had to choose between a client with strong evidence but a complicated immigration history, overstays, denial, status changes, or a client with a clean record but average evidence, which case do you actually prefer working, or why?
What would you do?
So weaker evidence, easier to overcome, 100%, because I could guide you, okay? We could try to make it work. I could try to get you to get some additional stuff. I'm able to work with that, okay? Thing is, with complicated immigration history, that happened already. Okay, so it becomes a bit more complicated. So in my opinion, I would prefer the client with the average case, but a clean, like a NIV history and no overstays, none of that. Don't get me wrong. Denials, for example, I know you mentioned the denial. That's not necessarily something that's detrimental to your case. Like, for example, if you're filing an EB1 and you had an O1 denied or a previous EB1 denial, that's not detrimental to you, okay? That doesn't mean that because you've had one denial in the past, you're going to get one in the future. I'm talking about overstays and that kind of thing where it does become a little more complicated. I'd rather the average case, clean history.
100% agree.
Yeah.
100% agree. You can, it's what Andrea's saying. You can polish out the evidence. You can get new evidence. I could be like, listen, go get a letter from this guy, go work on this, go do this. We do this literally all the time. We can work and make an average case into a star, but I cannot fix your overstay of 2 years. Like I can't fix that. There's no way of me fixing that. So I agree. Yeah. And great point on the denial. The denial won't prohibit you from applying in the future. Let's see. Belu, can I submit an EB1 online? Is that worth it? Look, I wouldn't, because here's the thing. The EB1, they're saying you could file it online, but then you have to file all these separate attachments for all the exhibits, right? So it's just like an EB1 case is minimum 300 pages.
Yeah.
Minimum.
And that's a small case.
And that's a small case. So it's like, I think the maximum, I think I read something like 12 megabytes. I might be totally messing that up, okay? But hold on. You know what? Out of curiosity, forms available to file online. Let's just look as to what it is.
It's because that's when it becomes complicated. Like,
right.
Are they able to accept all the evidence?
Right. And so it was like, I can't find it right now. But I remember at the time when I was looking into it and I was like, oh, let me go ahead and do this. I could file the I-140 online, but in order to file all of the evidence attached to it, I would have to make like 200 exhibits and attach each exhibit. And how do I know that that officer is actually going to like follow it correctly in the order that I want to do it? So I'm not doing it yet in particular, just because filing of the evidence has been such a nightmare. There it is. Yeah, man, I don't usually remember things, but when I do, capped at 12 megabytes per file. Mija, that's never going to be my evidence. I'm going to attach like 200 files and they're never going to read it in order. So I still prefer sending the paper package until they figure out what a better way to do it of submitting 400 plus pages.
I'd rather be old school in that sense.
I'd rather be old school.
Because it's all organized.
Yeah.
It's there. They get to review it a certain way, the way exactly. I wanted them to review it.
I put it in the order and in the color that they want it to look at. 100%. Yeah, I want to do it.
Yeah. All right. So we have here Angela Riascos. In April, we filed I-45 after I-140 was approved. Approximately how long would I expect to get the work permit? I would say 5 months approximately for the work permit.
Konya, you think?
Yeah.
I've been getting them in like 2 to 3.
I would say 3 to 5 usually, but because everything keeps getting delayed, now I want to be conservative and say 5.
That's fair. That's allowed to be conservative. Fair, totally. I love it.
Thank you. Thank you so much.
Edu y Papa. If I'm waiting for EB-290W not physicians, is that still paused? So no. So the adjudication, unless you're from one of the 19 countries, the adjudication of EB-290W is not paused. If you are from one of the 19 countries, yes, it is. But if you're not, they could still give you an approval on your I-140. No problem. Like we're getting those approvals every single day. And our fees and everything. But by the way, they haven't explicitly said that physicians are exempt. I know that's not your case. You said not physician, right? But for physicians, they haven't explicitly said that they are going to start working on them for I-140. They did explicitly cite H-1B and J-1. There's an assumption, and the word on the street is also that they're doing it for I-140. Basically, if you're from one of the 19 countries, but you're a physician, we're still going to push your case through. But we haven't seen it. For instance, I have several EB-290Ws pending for Venezuelan nationals and Cuban nationals, and I have not seen any movement, unfortunately.
All right. So, we've been talking a lot, very serious topics. And I know this is not the usual for the English show. It's a bit more serious, a bit more relaxed. But we have someone here that says some beautiful things. Salvatore Castaño. Okay, Stephanie and Andrea. Today, the show is also a beauty pageant. Venezuela is winning both the legal and visual categories tonight. This has brought my ego to a whole new height. Okay. Yes, Venezuela is winning right now. And this is what you guys have to ask for the girl show. The girl show is just amazing.
The girls know what they're
Knowledge,
doing.
beauty.
Qué sutil.
Tell you, ego has been lifted right now. I needed this today. I really did.
She did come into the show being like, oh, my hair is dirty. I don't
did.
know. Pero te ves
Makeup.
fabulosa, mi amor.
Ay, thanks.
Es que son los ojitos, mi reina. All right. So Memo asked about EB3 other workers from Mexico priority date November 2022. Let's see. EB3 other workers. They're currently adjudicating February 2022. God, I'm so bad at this all the time. February, November. No, I still have to wait. When do you think I'll be able to apply for my work permit? I don't know. I don't know when there's going to be sufficient movement towards November 2022. So you are what? 9 months off? March, April, May, June, July, August, September, October, November. 9 months off. It may not be this year. More than likely, it's not going to be this year. Remember, you can only file I-45 once that date is current on the visa bulletin. Prior to that, you cannot be filing your adjustment of status. After filing adjustment of status, 3 to 5 months for a work permit, especially assuming that you're probably going to get biometrics after 30 days. But I do not put it at this year.
No, it's 2022.
Yeah.
Priority date 2022.
February 2022, and he's November 2022.
Yeah.
I just don't
Maybe
see
October.
Okay,
if there's a jump.
Great point. So the fiscal year for immigration begins in October, right? And we would assume that in October there's a big jump because that's when they release new numbers. We hope, but EB3 other workers historically isn't very positive in that sense.
Yeah.
You know what? Let's also talk about that because I had a consultation literally about that today.
Okay.
It drives me nuts, like grinds my gears that so many individuals, and it's always non-attorneys, by the way, mostly non-attorneys, do EB3 other workers.
There shouldn't be any, like there are very few instances where you have to, okay? Most of the time, you could go with skilled worker, you could go with professional, and that'll be so much quicker. We were talking about that today, actually.
EB3 and EB3 other workers, okay? Just for your knowledge, just for me to really go on a tangent right now. The only thing you need to show for an EB3 skilled worker is 2 years of experience, not an education, nothing. 2 years of experience. If you don't have 2 years of experience to show, then yes, I have to go EB3 other workers. But if you have at least 2 years, I could do EB3 and I'm cutting your wait time by at least 2 years. So if I have 2 years of experience, I cut by 2 years.
Yeah.
Every single day, I have consultations of individuals who say, yeah, they did an EB3 other workers for me. And I always ask why. This poor guy that I was talking to today, I was talking to him and I was like, oh, of course. So why? And he goes, I don't know why. And I was like, it was a rhetorical question. I'm so sorry. I didn't mean to. I was like, why? Why would they do that? That's so silly. Yeah. This was a guy, mechanical engineer with 16 years of experience. Like, why would you do an EB3 other workers? It makes no sense.
I feel like it's when you say it's non-attorneys, it's probably they don't know, okay? Because it's not like it's a high bar.
I just don't understand.
It's 2 years of experience.
I don't understand. Because it's like basically, and then it's also like, God, I am just, you know what? I am on one today. I had another one that was a goalie coach. And it was a goalie coach. And he was like, a big time goalie coach, okay? Like stars.
Okay.
EB3 other workers.
There's so many other options.
This guy has, yeah.
So many.
Encima.
So many.
Encima that I didn't even want to waste this guy's time in telling him that, buddy, you should have done an EB1. But EB3 other workers, this guy has been goalie of like the top soccer players in the world for 20 plus years. Anyway.
It's worth it. It really, like if you're, let's say right now you're thinking of doing some sort of perm, think about what we're saying before you move forward, okay? Skilled workers, professionals, so much better than other workers. Yes. For you.
Yes.
Okay?
For your own wait times, for your own sanity. Yes. Ponte ahí.
Okie dokie. I have Belu again.
No. Go to start.
Oh, sorry. Okay.
I make it easy for you, sweetie.
Thank you. All right. Johnny Perez the third. once I sign with the firm, what should I actually expect in the first 30 days? Because I've heard stories of people who pay and then never hear from their attorney again. Not us. Okay? So you sign up with the firm. We'll know that you signed up with the firm, okay? And I want to say, yeah, we'll get notified. And we got like a physical document as well in case, we didn't see the email. So we got notified that you signed up the case. And then I want to say maybe maximum 48 hours, you'll hear from us. Even like, thank you for signing up with the firm. And here are the next steps. Okay. Like we do this introduction and you either hear from the attorneys or you're hear from the staff, but you'll hear from somebody. Okay. And we pride ourselves because of communication. We have a lot of clients that come from other firms or clients that have had bad experiences where it's like, oh, I paid and then I never heard back, or I paid and they took my money, or I paid and, I never heard anything until everything was filed, or months later. No, we don't do that. Okay. We pride ourselves in the communication. We think communication matters. We'll have a lot of back and forth. Sometimes I think you'll even complain about the amount of back and forth because we try to be as thorough as possible and try to keep you in the loop as much as possible so that you know what's going on. Okay. Especially, and I think about it like this, let's say I'm not in the US. Okay. I'm a foreign national. So I have no way of really knowing what's going on. I'd rather somebody keep me constantly in the loop and give me, even if it's unnecessary updates, because I'll know that one, they're taking my case seriously. Two, that I'll have that open line of communication that I think is so important, especially with people that have had bad experiences in the past. I feel like they have a little bit of PTSD in that sense. So no, at least not with us. It's not that we'll take your money and you'll never hear from us again. That's not the case. The second you sign up, we begin the documentation. A lot of the times we've even talked about documentation before we've even signed up the case. So we're pretty far along by the time you actually sign up because we try to move everything as quick as possible for you. Okay. So at least have some peace of mind knowing that with Beltran Brito, you'll have communication.
Yeah. Let me see. I have a question from Carlos. I have a TN visa. If I filed an I-45 with a pending I-140, if this I-140 is denied, can I still use my TN visa? What happened also with my dependents with TD visas? If you did not utilize the work permit connected to the I-45 and work with another employer, you can continue to use your TN visa. For your TD dependents, if they did not use the work permit associated with the I-45, then they never violated the TD and they can continue with TD. However, I put an asterisk here because the second you applied for a concurrent I-140 and I-45, you demonstrated immigrant intent, and TN does not allow immigrant intent. So while you can continue to utilize your existing TN, you will have a huge issue in renewing the TN because now you're going to have to mark that you have previously filed an I-140 and an I-45, right? I-45 being the real problem there. And you have now demonstrated immigrant intent, which is completely contrary to your TN. So you can continue to use your TN, but good luck extending it. You're probably not going to be able to extend it.
Yeah.
Vaya con Dios.
Yeah, Dios. All right. Let's see. Claudia, I responded to an RFE back in 2024 and still no answer after multiple requests and calls. Hold on, is there another one there?
Yeah.
Case was escalated to tier 2. Just got an email saying they're resolving it in 30 days, but no guarantee of a response. What can I do? So we've seen those emails before that they'll say they'll get back to you in 30 days with some sort of update. It doesn't mean that you're going to get a decision in 30 days, okay? They'll probably just give you an update, maybe saying case is still under review, and they'll send you a decision as soon as possible, okay? Don't think you're the only one. That happens often. There's a lot of delays with USCIS. So other than waiting, because you already did like some sort of service request, there is not much else you can do. Maybe an ombudsman where you're saying, hey, look, cases outside of processing times. But think about it like this. Certain I-140s, for example, like the EB2 and IW, the current processing times in the USCIS website says 25 and a half months, okay? So there is a significant delay. Doesn't mean it'll take that long, but those are the approximate times, okay? So even if they told you this, that it got escalated to tier 2 and that they're resolving it, I'm pretty sure they told you that they'll get back to you in 30 days. That's usually what they say.
You know what I've been having a lot of luck on? Congressional assistance.
A lot of people do this.
It's been actually quite useful lately.
Yeah.
And you know why? I'm going to be cynical.
Go for it.
Because they have elections in November.
Yeah,
they have elections in November. So surprisingly, it's a really good time to ask for help from a congressman because the congressmen are like, oh, I have to attend to my constituents super, super well because I want to be reelected. So you can reach out to a senator or a congressman being in either if you're already in the United States, being in the city of the state where you're currently living, or if you're not in the United States, then it has to be the city or state where your attorney is, and reach out to the congressman. They all have on their website immigration help. And so you fill out that form. Typically, they have like a form. Each of them it's different, but it's pretty much all the same.
It's like a tab, like a drop-down menu, usually.
And then you fill that out. And I've been actually getting a lot of results on that. And I would say if it's prior to November of 2026, which is when we're having elections, I think it's actually a good move to do congressional.
You have nothing to lose.
You literally have nothing to lose. Carlos is a follow-up. I'm extending the TN now and plan to file I-45 after getting the extension. Carlos, I ask you this. Why are you filing the I-45 if you don't have a decision on your I-140?
Important.
Do not. Unless you have an age-out kid and you're trying to protect the age-out kid, I can see a situation where maybe you want to protect it for potential CESPA purposes. Remember, the CESPA isn't even protecting because they changed their formula, okay? So be careful there. But unless you have a potential age-out kid, there's literally no reason for you to file that I-45 until you are confident your I-140 has been approved. Because you will affect your TN visa in the future and it will be difficult for you. And you're pagando por gusto. You're sending the money without any 100% chance that you're going to be fine.
You could lose it.
You could lose it. I would not file an I-45 until you are confident that I-140 has been approved.
Tell him, Steph.
Tell him.
All right. Mental health, then lightened. Oh, mental health enlightened. Wow, I'm loving this. You guys will probably tell me I'm living under a rock, but how do I actually start a case with you guys? Oh, you've come to the right place. You could contact us directly on the website. Hold on, I know somewhere here. Wait, right there where it says Beltran Burrito. Contact us. You could contact us there. Reach out to us. We'll probably ask you for basic information just so we're better able to assist you. And that way we get to help you out and we set up a call. Whichever one of the attorneys, whether it's Stephanie, Alexis, myself, Gil, whoever, you get to pick or you get to say any attorney and we'll reach out to you and help you out the best we can.
You see that little box right above your head?
Oh, the QR code.
That's a new move that we got.
Right here.
You can hit up the QR code as well.
That's awesome. Yes.
Ay, Carlos, mijo. We all are from Venezuela. My family has TD in their Venezuelan passport and the visa's expired in June 2013?
2023?
June 20th?
Oh.
The visa's expired. Okay. File extensions. File TD and TN extensions, but do not file the I-45. My advice stands. Thanks for the advice. You're welcome, buddy. Sorry for yelling. JP, si hablamos español.
Yes. Hablamos inglés, español. Alexis dice que habla portugués.
I see. That's the best one. On the website, I think Alexis still to this day says Portuguese, dude. And we had a Portuguese guy call in, and we were all just looking in his office to see how he would handle it. This man. Oh,
Yo
my
puedo
God.
hacer tu abogado.
Horrible. We make fun of him all the time. Let's see. Study first. For perm case, I know the sponsor is responsible for payment and contract with you. That is accurate as attorneys, but it is my case and I need to be involved and communicate freely with the assigned attorney. Is it possible with you? Yes. Now, you are going to notice with every attorney for a perm, we have to keep things very, very separate because we want it to be we want to be as conservative as possible and not affect your case. But you will be kept informed absolutely of every single step of the way. There's sort of an aspect of dual representation when you're handling perm cases. So it's not the expectation you may, not the communication you may expect, right? You're not going to be on the same emails as the company, right? Because they're going to be private information with the company, especially regarding the company's tax returns and all that information. But you will be kept abreast of every information, and there will be communication with you as well.
And updates, which is important. Okie dokie. Oh, my favorite visas, always and forever. It's Happy Tech 123. Is agent route the only way to have a flexible O1 where you can accept either independent contract work or W-2 roles? A bit confusing on the structure. Yes. So this is the thing. With O1s, the way I like to explain it is 2 routes. Route number 1, you have an individual petitioner. It could be anyone so long as they're a U.S. citizen, lawful permanent residence, or a management agency. And then you have 2 offers from 2 separate companies. That route, which is the agent representative route, that's the route that doesn't limit you to working exclusively with your petitioning company. Because route number 2 is where you have a company active and registered in the US that's acting as the petitioner and the employer. That second route limits you to working exclusively with that company for the duration of your O1. So if you want to have that flexibility, for example, if you're in the entertainment industry, in the music industry, those kind of things, you want to have that flexibility. You want to be able to work in any opportunity that may come your way. You don't want to be limited to strictly working with one company. That's the route you want to take. So the agent representative route, that's the route that's going to give you that flexibility in comparison to the other one.
Bueno, Andrea.
Bueno, Stephanie.
Creo que I think we have arrived. If you have any other questions, obviously, as always, you can hit us up on the QR code. You can hit us up beltranbrito.com/contacto. Hold on, let me hide the current comment. And we can go ahead and have a consultation with you, discuss your immigration particulars. We usually ask for you to upload the CV or resume onto that website so we could already take a general idea of who you are and already start thinking of some ideas once we're in the consultation. And we are here every Tuesday, 4 p.m. Eastern. Every Thursday in Spanish at noon. So if you want to practice your English or your Spanish, we are here. ¿Qué les puedo decir de más?
Keep asking us questions. Take advantage of it. Tell your friends. I know a lot of
Tell your friends.
Tell your friends. Tell your family. No, honestly, take advantage of it. I think it's a good opportunity of attorneys that sort of know what we're talking about to give you some sort of advice and honest answers. Okay, it's not just what people want to hear. We'll tell you what's actually going on and what benefits you at the end.
Wait, hold on. Juan Carlos was so nice. I was so close to filing for asylum thanks to bad advice from friends and other lawyers. Beltran Brito helped me get an O1 for a talent, and I never even took it seriously. It was just a hobby. You see? I literally say this all the time. Your hobby could be your O1. We say this all the time. And do not, if you could avoid asylum, try not to do it because there's so many other better ways in order to get visa and work opportunities and green card in the United States. So I'm so happy, Juan Carlos, that we were able to do that for you. So happy. And then study first. Yes, don't worry about it. Have the consultation with us. You could have the consultation with us first.
Yes.
Okay. And then we could have the consultation with the company right after. And we could set up everything with you first. Don't worry.
You could ask us your questions first.
No te preocupes. We can do it. Thanks, guys. Until the next time.
Hi, guys.
Oh, no. I'm so sorry.